Welcome to Law Sessions. I'm Jennifer Housen. In this session, we will explore land law and in particular the areas relating to registered and unregistered land. Now, land law does require an understanding of registered and unregistered land, and again, it is one of these things that is the bane of a law student's life, and in particular a law student doing land law, because it seems as if it is one of those areas that is difficult to grasp. But again, what I will try and do in this session is to make sure that at the end of it, you do understand the two concepts and how they relate to any question that you have to answer in a land law question. Now remember, from the introduction and the lecture before the unregistered and registered land lecture that we're dealing with now, I did say to you that in order to properly understand land law, you really need to get to grips with the right that is being discussed. You need to determine if that right is a legal right or an equitable right. And then you have to determine whether or not you're dealing with that legal right or equitable right in registered land or unregistered land. Now, in the introduction, we did consider the context of the other two under the general principles, and we did see, for example, how you determine the right. Generally, the law examiner will tell you, or the facts themselves will give you some indication. So if, for example, the law exam question says to you that A allowed B to move into her spare room for a nominal fee, more or less, you are going to discuss something along the lines of a lease or a license, because of course these are two parties who are in a relationship where one is allowing the other to live or to occupy on terms where they are paying. So what we're considering now, though, is this third heading, and that is registered and unregistered land law principles. Now, in order to properly understand English land law, you must understand the distinction in the rules governing unregistered land and the rules governing registered land. Most land law exam papers, as I say, will, of course, cover one of these, but the vast majority of questions will focus on registered land. So even though unregistered land has diminished somewhat in the UK, you will still need to know it. But when you look at the exam paper, 9.5 times out of 10, you will be dealing with a registered land scenario. You still need to know about unregistered land in order to know, for example, what the issues are, for example, in relation to adverse possession. Now, that is one area, squatters' rights, which you still need to understand the concept of registered and unregistered land, as it may very well ask you in a scenario to do with adverse possession. That said, though, if the examiner has not told you that it is a registered land situation, you may very well have to discuss what the rules are in relation to both types of conveyancing. Now, how does the examiner tell you? Well, you will get an exam question that will generally start off like, for example, X is the registered owner of Blackacre. That's a gift from the examiner. He's telling you it's registered land. Or if the examiner says that Y is the registered proprietor of Greenacre, again, it's registered land. Or it says to you, Paul and Mary buy a house and they were registered as the legal owners. It's registered land. But if the examiner just gives you a question, a problem question, but nowhere in it does it mention that the person's a registered owner or anything like that, then if you've read through to the problem and you cannot distinguish what it might be, then you must discuss the rules relating to both types of conveyancing. Before we even get to the distinction, though, let's just satisfy ourselves to a term I will use repeatedly throughout this session, and that is title deeds, or title for short. Whether you're discussing registered land or unregistered land, you will no doubt refer to the title deeds. Title deeds are a set of documents which constitute the proof of ownership of the property. They also show the past transfers of ownership, and you need them in order to transfer or convey the property and so deduce the title. Now, if I may pause here and say this as well, if you see the examiner using the word conveyance, and generally this turns up in an easement type question, that is a good indicator that you're dealing with a property that has been conveyed by deed, because that is important in determining whether a particular right is legal or equitable. And if it has been that the right has been given by deed, that will make it a legal right. Now, since 1990, it became compulsory to register land, and certainly from late 1990, the lands in England and Wales must be registered in order to transfer legal ownership. Now, prior to 1990, there were provisions for registration, but it wasn't compulsory, and we will explore that further when we consider registered land conveyancing. It is necessary to differentiate between registered land on the one hand and unregistered land on the other, as the deeds for each differ. Now, although this session will be devoted to unregistered land, in order to properly understand the unregistered land rules, we have to touch briefly on registered land at this point. It is almost as if by reference, you need to get to grips with certain aspects of registered land in order for it to make sense to you in understanding unregistered land. Now, unregistered land does not mean there is no paperwork, or there's no documentation, or there's nothing kept somewhere. In fact, it is quite the opposite. As a matter of fact, there is more paperwork for unregistered land than there is for registered land. So for our purposes, we need to examine registered land very, very briefly in order to show you then how unregistered land is relevant in that context. Now, very briefly, registered land is land where the title deed has been registered at the district land registry. And it has been registered at the district land registry in a register which is guaranteed by the state. The objective, of course, behind registered land is to create a register, something tangible, which will reflect somewhat accurately the state of registered land by showing who the current owners are, also possibly who past owners are, what are the proprietary rights, whether there is any third party rights, meaning are there any rights that a third party might have in or over that property. So theoretically, a purchaser should be able to look in one place at the register as it relates to any piece of property in England and know about that property, and they need not look anywhere else. That's the idea behind registered land. The reality, of course, though, is, as we will see in registered land, there are some issues which will need to be considered, because there are some interests, even in registered land, which unfortunately, although they affect a purchaser adversely, you cannot register them, and we will discuss that later. So the idea behind registered land is that it is registered at the district land registry. So then, what is unregistered land? Well, in some jurisdictions, this is also termed common law land. And it does not mean, as I said earlier, that there are no records or there is no owner. Rather, unregistered land looks at land where there is no entry on the register of title at the district land registry. So when you consider registered land, there is. Unregistered land means there isn't. Now, title to registered land is proved by title deeds and, of course, possession. And I'm sure you've heard the expression, possession is 9/10 of the law. Well, the rules of land registration do not apply to unregistered land, which is why you need to know what the rules are, so that if, for example, you're looking at, say, an equitable easement in unregistered land, it is dealt with differently than an equitable easement in registered land, and so on. Now, although all land in England and Wales is pretty much covered by the process of compulsory registration, well, up to recently it was said that about 20% of land still remain unregistered land, but that is of course reducing each time a piece of property is sold, because it then goes into the land registration system. Now, registration, of course, the system currently demands that there be registration only upon sale. So if you sell a piece of unregistered land, then the system says that it ought to be registered upon sale. But unregistered titles will continue to be in existence until it has greatly decreased. Now, if we consider ownership and proof in relation to unregistered land, if your ownership is not registered, proof of ownership theoretically faces a problem in the absence of registered title. The only way to show how you acquire title is to show the deed of conveyance from the vendor to you. Now, another name for the vendor, of course, is the seller, and that's the term that you generally use in practice, is the vendor. Now, deed proves your ownership. Now, assuming the seller owned it at the time of the sale. So if X comes along with a better title than your seller, what we get is a competing chain of titles. So let's assume, for argument's sake, X sold you the land. But as you've been living on it, you are quite unaware that Y had bought that same property 10 years earlier from Z. So he's got title deeds showing that sale to him. What you've got then are two competing chains of title. That, of course, requires a determination of who then is the real owner. The real owner, as it were, may be Y who bought from Z. But the question to ask is, have you, for example, lived there for 12 years? I'm going down the route of adverse possession or squatters' rights here. Or have you lived there for 15 years or more? Because that may then give you what is called good root of title. Well, the two options you have then are, first, under the Limitation Act of 1980, an action to recover land is usually barred after 12 years. So you are stopped from bringing an action to get back land which you may or may not have an estate in if after 12 years you have done nothing. So in other words, if you can trace your title back through a series of lawful links for at least 12 years, it is unlikely to be challenged. So even if the vendor did not own it when he sold it to you, then now that you own it, you may be able to obtain title based on adverse possession or squatters' rights. But here, if the land is unregistered land, as I say, legally, you could own it after 12 years. Relying on that then, the second point is that conveyancing law only requires and only allows a purchaser to trace the seller's title back 15 years. So the vendor is only under an obligation to, first of all, produce a good root of title, that is a document which shows at least 15 years of ownership. And second, starting with this good root of title, to then produce proper evidence of the subsequent legal history of the property dealing from one transaction to the other. Now, since the 1925 legislation, tracing good root has not been difficult because it is easier to, of course, ensure that the deeds are contained in a formal document. And in unregistered land, any property right, meaning a proprietary interest, including the legal estate itself, will fall into one of four categories. And the category determines what, if anything, the owner of the interest needs to do in order to protect that interest. And further, whether it will bind a purchaser of the land. Now, there are four categories, and they are these. The first is land charges registrable under the Land Charges Act 1972. The second are legal interests which are not registrable under the Land Charges Act, but they are good against all the world. You then have equitable interests which are liable to be overreached. Equitable interests which are not registrable or overreachable and are therefore subject to the doctrine of notice is the fourth one. What we will do after the break, of course, is we will look at these four categories in depth. And so I hope you join me in the second part so that we can continue.